Well, that's right. In D.C., they banned handguns in '76. If you had a pre-'76 handgun and you continued to live in the district all these decades, you could keep on owning that. And you could also own a rifle or a shotgun. But even with any of those legal guns, you could not, it had to be locked up or disassembled all the time, even if you were attacked in the home. There was, the law specifically prohibited putting the gun into an operable state for self-defense. And D.C. defended that law at the trial court in the case that became D.C. v. Heller.
All right. So that was, what year was that? That was 2 years ago.
That was decided in 2008.
Right. 2008, the Supreme Court says the federal government, and D.C. is controlled by the federal government.
It's a federal enclave. All the D.C. City Council's powers are delegations from Congress.
All right, so they're not a state, but Heller says the federal government, it is true, you cannot take away an individual right to keep and bear arms. That left a question about what about the states? That is, all right, so the federal government can't take away our individual right to keep and bear arms, but the state of Colorado, the state of Michigan, perhaps the city of Chicago, they can do that. That hadn't been decided. What was the difference between Heller and this issue of whether or not states and localities can do it?
It's the next legal question is the Bill of Rights, as most courts before the Civil War ruled, applies only to the federal government. After the Civil War, Congress saw that caused lots of problems. The censorship of speech that criticized slavery in the South before the Civil War, all the abuses that were going on in the South after the Civil War, including the disarming of the freedmen and state laws against the former slaves possessing guns so that they could defend themselves from terrorist organizations like the Ku Klux Klan. So Congress proposed to the states, and the states ratified the 14th Amendment. And among the purposes of the 14th Amendment was to make all the Bill of Rights apply to all state and local governments.
But let me kick that back to you because this is important. So if the city of Boulder, the city of Denver wants to say we have an official religion, the religion is Buddhism, and that is the official religion of the city and county of Denver or the city of Los Angeles, why can't they do that? It's not the federal government. The federal government obviously can't establish a religion. The federal government can't take away your right of free speech or to petition the government or right of press. But there's nothing in the Bill of Rights that says your state, your locality can't do that.
That's exactly right. So if in 1859, say, in Colorado had been a state, Boulder would have, if run by the current people, set up an official state religion called Recyclo-Buddhism, where the main thing was you had to recycle everything at all times.
And once a week you would go down with your offerings of newspaper and tin cans and
that's
offer to the gods.
You'd participate in the cycle of nature. After the Civil War, because of the 14th Amendment, then it was intended by Congress and by the people to make every part of the Bill of Rights enforceable against state and local governments. And so, therefore, the establishment of the clause against establishment of religions, which was originally written only as a limitation on Congress, became a limitation on all state and local governments as well.
What part of the 14th Amendment did this?
What was intended was the clause that said no state may abridge the privileges or immunities of citizens of the United States. And among the privileges or immunities of citizens of the United States is all the specific rights in the Bill of Rights. The free exercise of religion, right to keep and bear arms, freedom from unreasonable searches and seizures, and all that. It gets complicated, though, because the Supreme Court then in an 1873 case and then followed in an 1875 case, the Slaughterhouse cases and then the Cruikshank case, basically nullified the privileges or immunities clause. And the court then, because of all the labor unrest in the late 19th century, got very leery of making state and local governments obey the First Amendment, for example, because labor agitators were using their freedom of speech. Starting finally in 1897, in one small step on taking a property without just compensation, and then in 1925 on the freedom of speech, and then going through the 1960s, the court ended up using another clause of the 14th Amendment to, one amendment at a time, make portions of the Bill of Rights enforceable against state and local governments.
Let me kick that back to you. Let me see if I understand what you're telling me. So the 14th Amendment says the Bill of Rights is not only on the federal government, but on all levels of government. Your state can't take away your right to free speech, or your city council, or your park and recs department. They can't tell you you don't have a right of free speech. We all seem to get that. In today's America, we understand that your school board can't tell you certain things that you can or cannot do in your home, or what you can write in the newspaper. We get that. But when it comes to the Second Amendment, we seem to think that, no, that's a different thing. The Second Amendment doesn't apply. The we the people part of that, the right of the people, isn't the same as in the First Amendment or in the Fourth Amendment. And this case from Chicago really clarified it. Give me the background. What happened in Chicago?
Well, the day that Heller was decided, Alan Gura, who was the winning attorney in the Heller case, filed suit against the city of Chicago, saying that Chicago's handgun ban is unconstitutional. And that directly raises the issue of, does the 14th Amendment make the Second Amendment applicable to state and local governments? And that's the case. And the NRA filed a parallel suit, and the cases got all kind of jumbled together at the Supreme Court level, with Gura's case, the McDonald versus Chicago, being being the case the Supreme Court took. But the National Rifle Association got brought in as a party, as did Oak Park, which was the one Chicago suburb that, there were 5 Chicago suburbs that had handgun bans. 4 of them repealed them within weeks of the Heller decision. Oak Park tried to keep its ban.
So after Heller, which happened in 2008, most cities realized if we have an out-and-out ban, that's unconstitutional. Chicago, Oak Park said, we don't care. That's for the federal government. We're a local government. We have the power to do that.
That's right. There were only 6 cities in the country that had handgun bans, Chicago and 5 of its suburbs. 4 of the suburbs immediately realized it was unconstitutional. Chicago and Oak Park said, we'll take the case all the way to the Supreme Court, and they did, and ended up losing 5-4.
All right, so this case that just came out and was ruled on just a week ago, the Supreme Court 5-4 said what we said in Heller applies not just to the federal government, it applies to every government, just like the First Amendment, just like the Fourth Amendment. The Second Amendment is an individual right, and all governments through all levels of the United States need to accept that.
Exactly, just like almost all the Bill of Rights, with the Supreme Court doing this one step at a time incorporation, has made almost all the Bill of Rights enforceable against state and local governments.
What haven't they made? I mean, I can't imagine that the governor of Colorado, even despite any differences we might have, is going to start quartering troops in our homes without our permission.
Well, that case has actually never been decided, and partly because, fortunately, we have a bipartisan tradition in the United States of not quartering soldiers in people's homes. But if you ever did, that would be an appropriate case to go to the Supreme Courts, right? The Third Amendment has never been decided. The Fifth Amendment, most of the Fifth Amendment is incorporated, except the right to a grand jury indictment before a criminal prosecution. But that may get incorporated soon, because the Supreme Court opinions in Heller made a big, and McDonald versus Chicago, made a big point of saying that this grand jury case was decided so long ago, and they were sort of questioning whether it's really a valid precedent anymore. It's an 1886 case.
Well, when you use the term incorporate, for those not, we're not talking about incorporating, making it into corporation. You're saying that one by one, the Supreme Court has said the First Amendment, not only does it apply to the federal government, but the state and local governments. The Second Amendment not only applies to the federal government, they can't take away your right to bear arms, but either can the state of Colorado or the city of Denver.
Exactly, incorporated into the 14th. The 14th Amendment applies to the states. It has phrases like "no state shall." And so incorporated means that the body of the Second Amendment comes into the body of the 14th Amendment and becomes enforceable against the states. All right.
How big are these two decisions for those of us who care about civil liberties and Second Amendment rights? Give me an idea. Is this the Roe versus Wade for those of us who are Second Amendment supporters?
I think it's a very big case. Roe might not be comparable, because Roe was so much of the court just announcing it, out of its own willpower, rather than having a solid base in the rest of American law. The thing is, we have, one of the reasons we know that the Second Amendment is a fundamental right is because 44 states in our country already have a right to arms in their state constitution. So you want an idea, what do the American people consider so fundamental? Well, the fact that they put it in almost all their state constitutions, that's a pretty good guide.
But at this point, it doesn't matter whether or not they have it in their state constitution, because the Supreme Court has said the Bill of Rights, when it comes to the Second Amendment, applies to the states, even if you haven't explicitly put it into your state constitution.